In this industry, it seems like people are going to make the same mistakes over and over and over. So what would you say the number one mistake that's made by a regional office or an initial denial?
Sure. The two that come to mind are rating evaluations and effective dates. So for rating evaluations, especially when it comes to musculoskeletal injuries, there's certain steps that the C&P examiner has to do during the C&P exam when it comes to measuring range of motion, for instance. And they're supposed to take active, passive, repetitive use and measure during flare-ups. Your rating is based on your worst day or if you're experiencing a flare-up. So oftentimes at the C&P exam, the veteran isn't experiencing a flare-up. And the C&P examiner will say, oh, no range of motion issues, where the legal standard is you're supposed to take range of motion measurements using a goniometer at the veteran's worst day. And if he's not having its worst day, then you estimate or guesstimate, and the veteran is supposed to show the examiner.
You know what? Because when I did my exam, my doctor asked me, hey, over the last 30 days, I want you to tell me what your worst day was. And then they asked me a question about, my range of motion on my back, my range of motion on my knee, because he measured those. But he's like, is it always like this? But he said, in the last 30 days, what's your worst day? How far could you move it? Is that the reason he did that?
That is, and that was a good C&P exam, or a C&P examiner at least, because oftentimes they'll just leave the flare-up section completely blank, even though the veteran told the C&P examiner, I have flare-ups once or twice a month. So it takes a VA accredited attorney to go through those C&P exams and find the errors so that we can say this was an inadequate C&P exam and the veteran needs a new C&P exam.
Is it hard to get a new C&P exam?
No, at that point, we would do what's called a higher level review and request a new C&P exam based on an inadequate exam. And I would present the legal arguments and show the flaws in the C&P exam. And hopefully the decision review officer would remand for a new C&P exam after the informal conference.
What's some of the other typical mistakes made in the initial denial?
Effective dates. So the effective date of a claim is supposed to be the date of the initial filing or the date of the intent to file prior to the initial filing. So an intent to file is a placeholder. It lets the VA know, hey, the veteran's going to apply or is going to file a claim within a year of filing this intent to file. So if the veteran files an initial claim 6 months after the intent to file, the claim is supposed to backdate to that intent to file. Now, say he files an initial claim and it's denied, and then the veteran files a higher level review and the claim is granted. It's still supposed to date back to that initial intent to file because the claim was continuously pursued. The VA gets this wrong all the time. They might grant an effective date of the last C&P exam or the date of the higher level review request instead of dating it back to that intent to file. So my job as a VA accredited attorney is to check all the rating decisions and check the effective dates to make sure the veteran got the retroactive pay that they're entitled to.
Well, that sounds like it could be thousands of dollars.
It is, absolutely, especially when you're up at the 100% rate.
Well, let me ask you this. It's really curious. I got my rating back and I had some disabilities that they gave me 0% on, like high blood pressure was one, and I can't remember the other, but I've got some ratings where it's, hey, there's a service-connected disability, 0%. Is that common?
It is very common. So a 0% is a non-compensable rating, which oftentimes is the VA acknowledging that you have a disability, but saying you don't have compensable symptoms. That's always a red flag for me. I check every 0% rating because oftentimes the VA undershoots the rating and you should be entitled to a 10 or 30% rating even, but they give you that 0%.
All right. So you've got the issues of the C&P exam being flawed. You've got the dates that they're supposed to go back to, maybe some 0%. Is there any other issues that you see on the initial denials?
Absolutely. The VA denying a claim for lack of service treatment records. Under the law, the VA is not able to deny a claim based on lack of service treatment records alone. Oftentimes, the veteran will have service treatment records and the VA just overlooks them. Other times, they won't have service treatment records because it's common for active duty members not to seek treatment for a condition because you're in the field or you would lose your flight status, or there's a multitude of reasons why active duty members don't go to the doctor. Also because you're not going to sick call from 5 to 7 every morning. So the VA and the government recognizes this and says that you're not able to deny a claim based on lack of service treatment records alone. But the VA does it all the time. So it's up to a VA accredited attorney to file that higher level review and say, hey, you can't deny the claim just based on lack of service treatment records. You have to consider the veteran's lay statement and any evidence that we submit after the fact, like private treatment records from after service. They would have to consider that as well.
Well, I'll tell you this. When I was deployed to Afghanistan, I was the brigade judge advocate. I was a major, and I roomed with the doc, and there were other people in the room. But I remember going to the doc and saying, hey, I have this issue, and we're in the chow hall, and he's like, all right, well, stop by and I'll give you something for it. And so this was like off the record treatment, right? Does that happen?
All the time. And often it's not documented. And a lot of the times the doc says, here's some Motrin, take some ibuprofen for all those aches and pains, especially when it comes to airborne or ruck marches or things that soldiers are doing every day that everybody has aches and pains. The doc isn't going to notate every time someone's got knee pain after an airborne jump, but that adds up for a veteran. And if they do 50 jumps over the course of 2 or 3 years and they're not getting notations for every time they get aches and pains, that's up for the veteran to develop for the VA in a proper lay statement of what they did during service and how it affected their body.
If you believe that your record is not adequately reflected, give us a call. We're the law office of Will M. Helixon. We are your warrior advocates. You defend the nation. We defend you.